The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, first case is Island Creek Coal Company versus DOWCP. And Mr. Mattingly, pleased to hear from you, sir.
May it please the court, I'm William Mattingly here on behalf of Island Creek. The case before you this morning concerns a case of statutory and regulatory interpretation. The statute and the regulation are pretty clear. If a minor is informed, communicated by a medical professional that he is totally disabled by pneumoconiosis, he has 3 years to file his claim. The facts in this case are pretty clear also. There's no question that Mr. Frazier was told in the 1960s, 1970s, and 1980s by 3 different physicians that he was totally disabled by pneumoconiosis. That came out at the hearing. It was there in the redirect examination by his own counsel.
That was not his testimony, I don't think, that he was totally disabled. He was told, that, according to him, he was told he had black lung, but nobody told him he had to quit working.
Judge, I don't believe that is the testimony that was taken.
Well, I wasn't there, but that's what's in the brief, I think, of the Secretary of Labor.
The hearing transcript is relatively clear. His counsel says, did physicians tell you you were disabled by pneumoconiosis? And he responds that he was. That's in my brief, and we've quoted those sections.
And how long did he work after that? Another 20 years?
No, he retired in 1988.
He retired in 1988. Yeah.
And the claim was filed in 2017.
Only 12 or 15 years.
So
This fellow, he went to work in 1952, it says in the coal mine, unless that's a typo.
that's true. But the question by the regulation and the statute is not, did you go back to work? Did you have a state claim? But were you told by a physician you were totally disabled by pneumoconiosis? That starts the clock that you need to file your claim.
Well, I thought the issue was a little more legalistic. The first time he was told was in the 1960s, and he went back to work, and there's a doctrine of forfeiture which basically says the clock starts again thereafter. It's a progressive disease and that type of thing. Then he was told in 1980s by Dr. Rasmussen that he was totally disabled. And at that point, he filed a state claim under the workers' comp. And he was denied that. And the argument is that the state decision rendered Rasmussen's advice a misdiagnosis. The BIA did not address that issue. The BIA addressed the forfeiture issue and said the forfeiture issue created, and therefore he was entitled to it. The forfeiture issue is really irrelevant because he is a clear statement. So the question is simply, should the BIA decide whether the state law is sufficient to create a misdiagnosis? It just didn't address it.
It didn't. And the Benefits Review Board,
And that's the issue in the case, isn't it?
in essence, played gotcha with me by saying he went back to work after the surgery. That's what the judge found. So therefore, you've waived the issue because he went back to work. But that's not what the judge found. He only found that he went back to work after the surgery in the 1960s.
That's 60s, exactly right. So there were two reasons to reopen the statute of limitations. The first one was the 60s by forfeiture, and the second one was in the 80s by reason of the state decision. The BIA treated the whole case as if it were the forfeiture issue.
Correct.
And never addressed the statute of limitations.
And I've asked this court to reverse the award because I think that the
Well,
facts.
that's on the merits.
It is.
Yeah,
And-
but it seems to me if there's a statute of limitations issue, we ought to have the BIA work that out, shouldn't we?
I don't think you
I
need
thought
to.
that's your main issue.
It is the main issue, but.
I mean, for
but
us to
there's-
reverse a finding of black lung benefits, we get into the standard cases. I mean, there's a lot of pressure against the company on somebody that's worked this long in the mines.
There is, but I'm relying on this circuit's decision in Consol v. Williams, which came up with the misdiagnosis rule, that in a black lung claim, if you had a prior black lung claim denied, that created the misdiagnosis rule. And in essence, the court ruled in that published decision that that misdiagnosis could not be used then to establish the claim was untimely, to start the statute of limitations clock. In essence, they read the statute and the regulation and found that that prior claim established extraordinary circumstances, which is something that I think we have to look at in this case. And the regulation refers to an excuse for not filing the claim as extraordinary circumstances. So Judge Niemeyer, the question to me is that
When was he told that he was disabled due to black lung?
in the 1970s and 1980s were the most recent
And what do you
interpretations.
And what do you suggest communicated to this gentleman that he was totally disabled?
Two physicians told him that. Two different physicians told him that. That was his testimony.
But I wasn't sure that they told him that, because Fraser's testimony at some point was very meandering and unclear and uncertain, and led the ALJ, who was the fact finder here, to say that he had never, it was never communicated to him in the form of a clear diagnosis. Now, what do we do with that fact finder?
I don't think that is a fact that is able to be found from the testimony. He was very clear in his testimony that
So
physicians
you're
had told
saying
him.
that- You're saying that the factual finding of the ALJ was clear error?
Yes, the ALJ's suggestion that it was not clear from his testimony is error.
Would the ALJ be in a better position than we are to decide that because he listened to the testimony or she listened to the testimony?
The ALJ is unquestionably in a better position, but the ALJ didn't trace the testimony correctly because
Was the ALJ talking about the 60s or the 80s?
the ALJ talked first about the 60s on page,
Yeah, I'm not interested in that.
Yeah.
I'm interested in what he said about the 80s.
it was in the paragraph concerning the 80s, and he said it was unclear when those diagnoses were given to the minor. It's not unclear. The minor testified it was in the 70s and the 80s. And in this case, the state claim, which came from the state of West Virginia, was litigated and filed based on a date of last employment in 1976. We don't have that in the case. The thing that's missing in this case for the ALJ to rely on that state claim is that the state claim was never alleged to establish extraordinary circumstances. Mr. Fraser never said, I relied on my 20% occupational pneumoconiosis award for silicosis to think I didn't have to file a black lung claim.
The fact that this gentleman has worked 33 years in the mines, and it could cut both ways, I guess. It could say, well, he's bound to have been told at some point during that 33-year period that he was totally disabled. But then on the other hand, it could cut the other way, and you would think, well, this is long past the point where the interim presumption kicks in, and somebody who has a coal mining history of 33 years, which is far longer than than most of the cases we have before us. The time in the coal mines doesn't approach 33 years, and I'm just a little bit uncomfortable with somebody who's worked that long in the mines, not receiving some kind of benefit. And I just, that troubles me. That's a long time for somebody. Maybe that was spent outside of the mines, but maybe it wasn't. What was the nature of his work during that 33-year period?
He worked in and around a plant, and he worked driving a truck.
He worked underground, most all of it. At the end, he was driving a truck.
But
He worked
remarkably,
underground. He was a slate picker.
that's all true, Judge, but remarkably in
For
this case,
33 years.
there's no X-ray,
Underground.
there's no X-ray evidence.
And he worked for Island Creek all that time.
That's right, and
And
there's
lived
no,
on Buffalo Creek and survived the flood.
and
And
there's,
survived he looks like a cancer operation. And he always went back to work.
and
He's
there's,
a typical,
well,
he's a typical Southern West Virginia coal miner.
He-
He always went back to work.
hardworking guy, but that's not the issue. Because if it was just, if
But
the Department of
23
Labor,
years and 15 years without underground work gives him the presumption.
but the presumption doesn't come into play
No, but you know about the
in this,
presumption.
in this case, because the question is not how
I'm
long did he
talking
work?
about I'm following up Judge Wilkinson's comment, and I'm emphasizing a couple of things that I picked up in the record here about his work. At the end, he was working on top, that's what they call it, driving a truck or something.
And he never developed clinical pneumoconiosis X-ray evidence, even with all that exposure.
How could
But
somebody work for 33 years in the mines and not develop pneumoconiosis? I don't understand that. That is just a long, long time to be working underground and not, many of those years must have been in when the reforms in coal mining and when conditions were in a more primitive state. I just am ultimately not comfortable with somebody who's worked 33 years and not getting any benefits. Do you understand?
I understand, and I think that is why the agency ALJ said, I have to look at this state claim and manufacture a misdiagnosis, which is what he attempted to do. And the regulation doesn't allow him to do that. Not everyone who runs a marathon wins. Not everyone who works in a coal mine for 30 years develops black lung disease. So the purpose of the act is to compensate those who are totally disabled by pneumoconiosis. The statute and the regulation tell a claimant they have to file a claim within 3 years of that communication.
If the state black lung claim was denied, doesn't that come close by operation of the law to say that the earlier suggestion of black lung, which was a little iffy to begin with, was a misdiagnosis?
It's not a misdiagnosis because we have different legal standards. The state claims operate under a different criteria than the federal
But the
black lung
state
claims.
gave him 20% disability,
That's correct.
and that's not 100% disability.
Well, you don't have to get 100% disability in West Virginia to
So
get
it's-
lifetime benefits. So there are differences in the tables and
And he
the
went back to
evaluations.
work and worked
Well,
for another
Which,
15 years.
the fact
or
that the
something.
state claim found that he had pneumoconiosis put him on notice, and then doctors said, you're totally disabled by pneumoconiosis, and he freely admitted that at the hearing. So the question is, was there a waiver based on the ALJ's finding that he went back to work after surgery in the 1960s? The board is simply wrong. That was not a finding that the ALJ made concerning the other two opinions. The two later opinions from the 1970s and the 1980s put him on notice he needed to file a claim, and he didn't do that.
How do you get back past the Secretary of Labor's position in this case?
You know, it'll be
They're
interesting,
opposed to you,
it'll be
100%.
interesting to hear in about 2 minutes what they have to say.
I know, but how you get past it?
But they're defending what the board did and saying that I waived the issue, trying to make a legal argument that it was waived. It was not. They have not weighed in on whether or not the later findings in the 70s and 80s do establish that this is an untimely filed claim. The ALJ had cited Sharondale versus Ross, a Sixth Circuit decision, and it's clearly not applicable. And I explained that in the motion to the board. That was the case that he cited.
You agree
It said-
that if you get past the statute of limitations issue, that substantial evidence establishes that this gentleman had pneumoconiosis?
No, because of two findings the ALJ made. He first found that Doctors Bashida and Doctors Aldevar.
How do we get to reweigh the evidence? Because the ALJ gave the opinions of Dr. Bashida and Dr. Zaldivar less weight than the opinions of Dr. Forehand and Dr. Go. And that just, isn't that a classic situation of whether substantial evidence supports the condition of pneumoconiosis? And I mean, you're asking us to reweigh?
I am not asking you to reweigh the evidence. I'm asking you to send it back to the administrative law judge because he found that Dr. Bashida and Dr. Zaldivar ignored the 30-some years of coal mine employment. And it's clear from their reports at Joint Appendix page 43 and 150, they both said this man had sufficient exposure to coal dust to put him at risk of developing pneumoconiosis, but for the reasons I give, it is not pneumoconiosis.
Okay.
My time's expired. I will be back for rebuttal.
Excuse me 1 second. Judge Niemeyer, do you have some questions? Or no. Judge King?
I'm good.
Okay, thank you.
Good morning, and may it please the court. My name is Amanda Torres, and I represent the director of the Office of Workers' Compensation Programs. The director requests that this court deny employer's petition for review. Employer forfeited its challenge to the ALJ's finding that the minor's return to work reset the clock on the statute of limitations because the employer failed to raise that issue at the time required, which would have been in its opening brief.
I agree with that. It seems to me that's inescapable from looking at the record. The BIA, however, relied on that fact alone to deny statute of limitations and did not address the 1970s and 80s misdiagnosis claim. And it seems to me that the statute of limitations with respect to the 1960s, the forfeiture claim, is irrelevant. But yet that's what the board relied on.
Yes. However,
The board basically said employer does not challenge, however, the ALJ's finding the statute of limitations reset when the claimant returned to his coal mine employment. That was in the 1960s, after the surgery. And so let's assume that's true. That's what was relied on. But that doesn't answer the question which was raised and not disposed of, which was and the court said he received a diagnosis from Rasmussen and two others in the 1970s and 80s, and that the claim was that there was a misdiagnosis, but the BIA did not address the misdiagnosis issue. And that was raised and presented to him, and the BIA says that. It relies solely on the forfeiture, which is irrelevant. And so it seems to me we should have at least a ruling on the statute of limitations, because he did file more than 3 years after receiving the diagnosis in the 80s.
yes, so the evidentiary record and the ALJ's findings are clear that the minor worked from 1952 to 1988 and that he returned to work after each of the diagnoses in the record. Dr. King mentioned the issues with Dr. White's diagnosis, and
I know, but this is all irrelevant. The whole issue from what I see, setting aside the merits of whether the man has pneumoconiosis, the whole main issue was that the BIA did not address the statute of limitations, which on its face was filed more than 3 years after he received a diagnosis. And the answer is, the minor is argued that the answer is there was a misdiagnosis because of the state claims filed. But the BIA chose not to address that. The BIA chose to rely on the 1960s forfeiture only, simply because the employer didn't present that. But the employer didn't present that because that was not material. He returned to work, and he can file thereafter if he develops pneumoconiosis. But yet the board relied only on the 1960s return to work. And that was exclusively because the employer didn't challenge that. And that's the holding. And so my question is, shouldn't we at least have the BIA render an opinion on the statute of limitations?
The court could remand to the board to review the statute of limitations, but it should do so regarding both the return to work and misdiagnosis rule, because the same reasoning that supports the ALJ's return to work analysis for the 1960s diagnosis applies to the 70s or 80s diagnosis as well.
You can make these arguments. You could have made them to the BIA. The BIA did not address that. And there is a complication in this case because there is no case that I'm aware of that relied on state diagnoses under the workers' comp laws. The doctrine of misdiagnosis has been applied in connection with the denial of benefits, of black lung benefits under the federal system. It may be a good argument, but it seems to me it's worthy to have the BIA address that in the first instance.
Yes, and so
that's never been addressed.
It has not been addressed. This
Okay.
court has not addressed it, and so to allay those concerns, then the response would be to remand for the board to actually determine whether
Yes.
the misdiagnosis rule applies to a
Would you be
state
objecting
claim.
to that?
No,
Yeah.
the director doesn't object to that remand. The director's position is merely that the result on return to work would lead to the claim being timely filed, and so it's unnecessary to go through the process of having to remand to the
You
board.
want us to conduct that analysis?
No. We are asking the court to find that there's only one reasonable result in this case on timeliness, and that is that the claim was timely filed because of the return to work analysis.
There was no return to work analysis with respect to the 1980 diagnosis. The analysis there was the ALJ relied on the misdiagnosis based on the state filings. And that is what the employer appealed. And the BIA did not address that. The BIA relied on the forfeiture in 1960s only to resolve the statute of limitations issue. That's irrelevant, and the other issue is open. And you say, well, it's an easy issue, we could decide it. But the answer is it's not so easy because we agree that no opinion has yet decided whether we can rely on state workers' comp decisions to do that. Maybe we can. There's a lot of good arguments.
To what degree does a subsequent state black lung claim that's denied make the earliest suggestion of black lung a misdiagnosis?
This court hasn't decided that. Now, the Third and Sixth Circuits have addressed that issue. The Third in Morris said that it can, as long as the reason for the denial was that the claimant didn't have pneumoconiosis. The Sixth Circuit in Brigance stated that where the reason was unknown, it couldn't trigger the misdiagnosis rule. That had an unusual set of facts where the claimant was granted state benefits for 8 years.
Let me just say, is it because remands always postpone these kinds of things? Is it open to us, in your judgment, to say here that the denial of the state black lung case did in fact operate to make the earliest suggestion of black lung a misdiagnosis?
I see that my time is up.
Is that open to us?
May I have time to respond, Your Honor?
Yeah, sure.
No, because the case would have to be remanded for the board because the board did not actually review the misdiagnosis rule. So there's no decision for this court to review from the board. The board fully applied the harmless error doctrine to avoid the question of whether the misdiagnosis rule applies to a state claim.
What are you prepared to argue if the case was remanded?
The director's position is that that's not properly before the court right now, and it would, we would have to make a determination at that time if it was properly before the board to make the
I must
arguments.
say that this is not the most helpful argument that I'm receiving as to what the director's position is, or what's open to us and what's not, and all the rest. I'm having a difficult time getting a response.
And I apologize, Your Honor. The director's position is that in this case, forfeiture and the harmless error doctrine applies to leave this court with no substantive review of the timeliness argument that the employer is making.
Your position is there was a waiver.
Yes,
At what point?
before the board. If the court has no further questions, I'll go ahead and take a seat. Thank you for your time.
Excuse me, I have a question. What do you contend the effect of the waiver was?
Of the return to work analysis,
Yes.
that this court should not address the substantive issues. Once the employer forfeited the return to work analysis, the issue of timeliness was no longer before the court. This court has.
The employer doesn't make that argument, though. The employer agrees with you that there was a forfeiture, at least by waiving it, and that's not the argument, the viable argument. The argument that was raised with respect to the 1970s and 80s diagnosis was misdiagnosis, and the court chose not, the BIA chose not to address that. They relied on the forfeiture with respect to the 1960s. And it seems to me that that's an incomplete, that waiver doesn't cover the ground.
And so the director is requesting that the court remand to the board for them to actually engage with an
Okay,
analysis.
it sounds to me that's reasonable, yes.
Yes.
Thank you.
Thank you.
Good morning, Your Honors. I'm Sam Petzonk on behalf of Mr. Frazier, and I'm just going to try to pick up, if I may, on the discussion, and I'd like to focus on Judge Niemeyer's concern about whether the board addressed the misdiagnosis issue. Because my reading of the board's decision and the ALJ's decision, if you look at Joint Appendix 256 and 257, which is the board's decision, and you look at the ALJ's decision at Joint Appendix 227,
The ALJ addressed it. The
Yes.
ALJ addressed two aspects. One is that there was a forfeiture with respect to the 1960s diagnosis. He went back to work, and the court relied on that. The ALJ did, I mean, the IJ did. The immigration, not the immigration judge.
it's the Benefits Review
Benefit- yeah,
Board,
right.
the BRB, yes.
But both claims with respect to limitations were addressed by the IJ. But the BIA laid it out that both claims were made. It laid it out that both claims were made, but then the court said, employer does not challenge, however, the ALJ's finding that the statute of limitations reset when claimant returned to work, his coal mine employment.
But
That
then
was
the-
the 1960s return to work.
Yes.
And so since that wasn't challenged, the court said that has been waived, and
But-
then it relied on that waiver.
But, Your Honor,
And
they,
did not
if,
determine the rest.
if I may, Your Honor, at JA 257, the review board says, even assuming arguendo that the ALJ erred in finding Drs. Combs, White's, and Rasmussen's diagnosis constituted a misdiagnosis, any such error was harmless.
Harmless because it
Because of the
relied on
return to
waiver.
work. But the court, the BRB did analyze and agree with the ALJ that there was no misdiagnosis, and that gets to Judge Wilkinson's point, which is, the standard of review here is limited.
Hold on, please let him make his argument. Go ahead.
Thank you, Your Honor. The standard of review here is limited, and I think Judge Wilkinson sensed exactly correctly that as a fact-finding function, this is there's classic medical fact-finding in this case. There's also classic fact-finding as to the presence of the misdiagnosis. And Your Honor is exactly, I think, correct, that you can defer to the ALJ and the board where the ALJ and the board find there was no factual trigger for the finding a misdiagnosis.
The question that I'm having here is whether the record taken as a whole, whether there's anywhere in this record that this individual received a clear diagnosis of total disability and due to black lung. And so what I'm trying to do is look at this record as a whole and say, is there any time that he received this clear, emphatic diagnosis of black lung that would have put him on notice that he had to move ahead and file a claim?
There was not.
And the problem that I'm having is taking this record as a whole. I cannot find that this gentleman received a clear diagnosis of total disability that would have put him on notice to go ahead and bring the claim.
And neither did the ALJ, and neither did the BRB. And they both said that, and the Benefits Review Board had exactly your analysis, that there was no finding of a total disability conveyed to Mr. Frazier, and so therefore...
If that's not there, the statute of limitations does not run.
Exactly. And if you look at JA 214, what Mr. Frazier actually explained on direct questioning was quoting him here, I can't remember any doctor telling me that. And it's the ALJ's fact-finding function to determine whether there was a diagnosis, and the ALJ set forth the right case law at JA 227 as far as the nature of the written clear diagnosis that must be communicated to trigger the statute of limitations under the Black Lung Act. The ALJ got all that law right, and no such diagnosis was made. That's a fact the ALJ found, and the BRB upheld that finding. And so, Judge Niemeyer, you really, I don't think you need to remand for that, because the BRB acknowledged what the ALJ found in this regard.
The BIA acknowledged that he claimed he had been diagnosed by 3 doctors in the 1970s and 80s and did not question that. The BIA assumed he was told that.
That's not true. If you read the BRB's opinion, Your Honor, at JA 256, they say, as the ALJ noted, the record does not contain any written evidence predating the filing the present claim to indicate total disability. And they go through and they talk about...
you know what the issue there?
Didn't he
Just a minute,
testify consistently that the doctors told him he had black lung, but never told him he couldn't work?
Exactly. So the ALJ found that fact, and the BRB...
They never told him he couldn't work, they never told him he was disabled.
Exactly. So I think, Judge Wilkinson, you've got your finger right on it, which is you can affirm the BRB and say, yes, he was never told, there was never a sufficient clear diagnosis of total disability.
You didn't read that record correctly. That record says that he never received the diagnosis in writing. He was told orally. And the court then concluded that made no difference. And then it went on to explain that the diagnosis did not trigger the limitations because there was a misdiagnosis. The very next paragraph. So the whole discussion there is whether it needs to be in writing. And it was clearly oral, but it was clear that he made that. He testified to that 3 or 4 times.
Well, respectfully, though, that is a fact finding by the ALJ, that it wasn't a sufficient diagnosis, be it in writing or be it oral. It's a finding of fact.
No, the ALJ acknowledged that. What the ALJ concluded was that it was a misdiagnosis. That's what he concluded. It didn't conclude that the diagnosis wasn't made by the doctors orally.
Well, in any event, I think I tend to agree with Judge Wilkinson that no doctor ever told this individual clearly that he was totally disabled, and so even if they had, the misdiagnosis rule would save him.
There's at least 3 or 4 times in the transcript where he said that. And he said it was Dr. Rat, he couldn't place it whether it was the late 70s or early 80s. But he said he was told that he was totally disabled by black lung. It was unequivocal. The ALJ says it, and so does the BIA report that.
I think
BIA, your whole quotation is to whether it was in writing. And the court, agency said, BIA said it did not need to be in writing. But it said the fact, and the way the court disposed of it is ALJ did it because it was a misdiagnosis, not because it wasn't spoken.
Well, actually, the case, if you look at the case law the ALJ relied on, the case, Adkins, says that it should be a diagnosis in order to trigger a statute of limitations. So I think he was applying the case law correctly as he understood it. But if you were to go ahead and find that there was a finding, an adequate written or other finding of total disability that was conveyed to the minor so as to trigger this misdiagnosis analysis, the rationale of the Williams case that Mr. Mattingly described certainly supports applying the misdiagnosis rule here. It doesn't matter whether the misdiagnosis is superseded by a state workers' compensation decision or a federal one.
That's an issue we've never decided, and is questionable. The other circuits are not totally clear on that either. And I'm simply saying that we have a Chenery problem on that. We don't, Department of Labor has taken the position, which I think is the right one. We don't have that decision before us to review.
Well, Your Honor, yes.
The 33 years that he spent in the mines, was most of that underground?
I believe that it was, yes, Your Honor. I think Judge King addressed that as well, yes. He did work towards the end of his career outside, but what matters under the Black Lung Act is whether you were regularly exposed to coal dust. He worked at an underground coal mining complex throughout his career. I think towards the end he was working at the outside part, but under the Black Lung regulations, it's presumed regulatorily that if you are working at an underground coal mine site, even on the outside, you still have dust.
If you're working in the site, the exposure.
Yeah, where the belts come out and dump the coal onto the ground, the exposure is presumed by regulation to be comparable.
I understand,
Yes.
but the exposure wouldn't be as intense as if he had worked underground.
Well, I think it's immaterial because the regulations presume that it is as intense in terms of your exposure history.
Island Creek operates underground mines in Logan County.
That's correct. Well, they did. Yeah,
They did.
Yeah. And
And he was with Island Creek the entire 36 years.
he had yes, that's right. He
52
had a long,
to 88, except while in the military or in the hospital.
that's my understanding. So I think that, again, certainly they forfeited their return to work argument, and there doesn't seem to be any disagreement about that. If I may, just with whatever time I have left here, address the substantial evidence issue on the medical findings. I certainly think you can affirm the BRB on the misdiagnosis issue because they did analyze the record adequately, and I hope you will, and there's no need to remand it. Certainly, Mr. Frazier is 95 years old at this point, and remaining this case could drag it out for an indeterminate amount of time. I hope you don't do that. But why the ALJ credited Dr. Go and forehand, certainly there's plenty of substantial evidence in the case to support that. Most interestingly here, the company's doctors claimed that this man had asthma. But if you look at the pulmonary function testing in this record, his breathing did not get better with inhalers, and asthma is an inflammatory condition that improves with inhalers. He had just a moderate amount of, just a barely enough improvement from the inhalers to even be perceptible under the pulmonary function testing standards. And so our, examining physician, the Department of Labor's physician, said there's a huge amount of fixed impairment in this man's breathing that doesn't get better at all with inhalers. And asthma cannot explain all of that impairment. So the ALJ reasonably credited those doctors with saying, here's a lot of breathing impairment here that that doesn't get better with inhalers, and that could only be explained by coal dust exposure. So there's plenty of substantial evidence and to support the the placement of greater weight on the opinions of Dr. Go and Forehand regarding the presence of totally disabling impairment. And likewise, as you've noted, Your Honors, there's certainly enough evidence to support the diagnosis of legal pneumoconiosis. It's long established that if an ALJ finds on the record that there is legal pneumoconiosis, then it's logical and proper for the ALJ to credit more heavily the opinions of the doctors who share that diagnosis. That's what he did here.
Suppose we are thrown back on the question of whether the subsequent state black lung claim was denied, and whether that operated to make any earlier suggestion of black lung a misdiagnosis. Is it your view that we should go ahead and not reach the question or resolve the question, or what is your thought about that?
Two steps, Your Honor. First of all, you don't need to reach it because, like you say, there was no diagnosis to get us into that analysis. The ALJ found there wasn't a clear diagnosis, and you can just acknowledge that, and you don't have to reach the substance of the, but if you go to the question of whether it's the misdiagnosis rule can apply by way of a state workers' compensation analysis, you should say that you should allow that.
But that's a much broader basis for deciding the case, and a lot of times when a court, I don't think there are any other courts, so they've all shied away from that, it seems to me, and I'm a little bit reluctant to charge into a broader question of the operation under law of a state black lung denial if I don't have to.
I agree, and I think, as you indicated at the outset, you don't have to. You can simply find there was no clear diagnosis under the Atkins.
Can I ask you a question?
Yes, Your Honor.
This is from the BIA's opinion. The BIA said, claimant testified Dr. Combs told him in the 1960s that he had black lung. Dr. White told him in the late 1970s that he had black lung. And Dr. Rasmussen told him in the 1970s or early 1980s that he was totally disabled to pneumoconiosis. Hearing transcript 23, 24, 34, 38, 40. Many times those things were testified to. And then the BIA goes in to launch into the fact that the ALJ also observed the claimant filed West Virginia claims and so forth. So I don't see any ambivalence in that, do you? Is there any other statement in the BIA that hesitates that that fact was not true or not clear? I mean, he cites 5, 6 pages of the transcript where the guy testified, and I found them myself.
Right, but I don't think that the ALJ found that that constituted a
I'm talking about the
communication.
BIA. Is there anything in the BIA that suggests that there was not a diagnosis? It looks to me like that just is as clear as a bell.
Well, I think that there is something in the BRB's opinion there which finds the ALJ never found that there was an adequate diagnosis to trigger the statute of limitations under the Adkins against Donaldson Coal Company case, which is what the ALJ relied on for that issue at JA 227.
These are all issues of whether you should apply the limitations, because first, there was an argument, a question about whether it had to be in writing, and the BIA said it did not have to be in writing. But then there's an issue of forfeiture, which was not challenged by the employer, and then there was an issue of misdiagnosis. And the BIA said it didn't need to reach that because there was a waiver.
Well, likewise, you all don't need to reach that, because even if there was even if the ALJ was factually wrong and there was a diagnosis of total impairment due to black lung, which I don't think the ALJ ever found that there was, but you all don't need to get into that analysis in this case, Your Honor, and I think
Was the BIA in error in making that finding?
I think that I just read that BRB decision a little bit differently, Your Honor. I think
I
with
just read it out loud to you, and I didn't see any exception or condition on that.
Well, they say even assuming that those findings were diagnoses that triggered the misdiagnosis rule, the error was harmless.
That's
Yeah, I
referring to the
understand
state
that.
determinations.
Right. I just don't think that it would matter regardless, because even if it does constitute a diagnosis of impairment which triggers a statute of limitations, it would be immaterial because the misdiagnosis rule would would resolve it in the minor's favor. So you don't need to get to that issue because the error would be harmless. So I hope you will affirm the BRB, not remand this case, and allow this man to conclude his federal black lung claim.
Mr. Mattingly, you have some time for rebuttal, sir.
Thank you, Your Honor.
The directors agreed that there are Third and Sixth Circuit cases that talk about state claims. There are. But those were state claims that were denied. When you look at this state claim, it was not denied. It was a 20% award. You can't use the shelter of the state claim to then say there was a misdiagnosis because it wasn't a denial. And that comes out of the Williams reasoning that in a federal claim, if you have a prior federal claim that's litigated and denied, the claimant can rely on that denial to wipe the slate clean of prior opinions. That same thing cannot happen in the interplay between federal and state compensation claims because they don't use the same criteria.
Why would we treat those differently in your view?
They don't use the same criteria. The state claim is a partial award. He got 20%. It's
Yeah.
not clear what that means, and it's not clear that that contradicts Dr. Rasmussen's
Okay,
assessment that was told to him.
Let's, I take your point with respect to the misdiagnosis rule and the fact that federal and state claims proceed on different tracks and with different criteria. But that still leaves, I think, your situation. The hardest thing, it seems to me, from your point of view, are those ALJ findings about his interaction with the doctors. And Judge Niemeyer points out and makes a good point about if we had been ALJs, we might well have said that these conversations with the physicians clearly told this man he had total disability due to pneumoconiosis, and then he's charged with filing a claim. But a lot of times, we affirm fact-finding, even though we have a notion that if we were the fact-finder, we might have done it differently. And I'm just wondering, those ALJ findings are the hardest thing, I think, for you to deal with, because they leave us with a record that in its totality does not convey the firm conviction that the necessary clear diagnosis was made to this man.
Judge, if you look at page 227, the last paragraph of the ALJ's decision there on that page, he states, claimant recalled Dr. White and Rasmussen finding him totally disabled from black lung. He cites the pages of the hearing transcript. In this room, I was the only one there for the hearing. The recollection I have is he was clear, although when you read the words, it does sound as if someone is stuttering or hesitating. But it was clear, and it was repeated multiple times. So I think you can take safe harbor in the ALJ's finding there. The other thing I'd like to point out, using the backdoor.
Let me ask you, does the ALJ question the testimony on that regard? It looks to me like he reports the same thing the BIA did,
I don't think he does, Judge.
In other words, there's no question that he agrees that he was told he was totally disabled by pneumoconiosis by at least 2 doctors in the 70s and 80s.
Correct. They looked for a way not to have to apply the
And
3-year limitation.
The only observation about it is the ALJ said there was no written evidence of that.
Correct.
And then it goes on to the misdiagnosis.
And this court ruled, and the ALJ noted, that same page, in the Hinline decision, it doesn't have to be a written. The statute and the regulation says it has to be a communication.
The board
Agreed.
agreed that it's not, so that's not an issue. But the question is whether there was a clear finding of fact. And the ALJ looked to me like he made as clear a finding as the BIA did.
I agree. The other thing, if I may, Sharondale versus Ross, the Sixth Circuit decision that talks about return to work, there are 3 reasons they find that claim was timely filed. There was a prior denied claim, and within 3 years of that denial, he filed his other claim. So the talk of return to work is all surplus. You didn't need to get there because it was less than 3 years, so the statute didn't apply with the misdiagnosis rule.
We thank you. Paul, do you have any further questions?
Nothing.
We thank you both. We'll come down and greet counsel and move directly into the next case. All right, next case is Malone versus the United States Patent and Trademark Office. And Mr. Mangrum.
Brett Mangrum for Josh Malone, the plaintiff appellant. May it please the court. The district court's opinion is incompatible with the Supreme Court's decision in Butts versus Economu. And I want to talk a little bit about, there's some important things in the briefing that your honors need to be aware of about the Butts opinion in particular. The Butts opinion makes clear that undisclosed consultations with adjudicators about facts at issue in a pending administrative proceeding are not protected deliberations. And what's important about the Butts decision specifically is in interpreting the Administrative Procedure Act, the Supreme Court said that any person or party, including other agency officials, concerning a fact at issue in the hearing, you may not consult any person or party concerning a fact at issue in the hearing unless on notice and on opportunity for all parties to participate. So that holding is critical here because the agency invoked FOIA Exemption 5, which protects only those documents normally privileged in the civil discovery context. So undisclosed communications that violate the APA's notice and
Do I understand in the facts of this record that the deliberations you're addressing are those with the pool judges?
Correct.
No, so it's all discussions among judges?
Correct.
So that if you have a district court, I was on the district court, and we had bench meetings every Wednesday. and we talked about the business of the court and so forth, and some judge would raise a question, has anybody decided a case or know of a case that talks about FOIA? And another judge might say, yeah, there's a case, take a look at Jones versus Smith. You would say that's an improper consultation among judges.
No, it was the nature of the consultation.
I mean, here there was a practice that they could take some look at it. The panel had the ultimate responsibility, didn't they, to make the decision? It's clear.
Yes, but the difference here, and I want to be very clear, at the time, most of the decisions were actually required to go to what was referred to as the circulation judge pool.
Yeah, but it seems to me the bottom line in your position is you don't even want judges talking to one another. You think that's governmental misconduct.
No, our position is that
No,
when...
that's right. You don't want judges who are not on the panel even offering an opinion or suggestions about a draft opinion. And every court in the country makes allowances for pre-filing comments from non-panel judges about how an opinion could be revised or improved or whatever, and that seems to me right at the heart of what the deliberative process is designed to protect. That makes, for one thing, if you have somebody, every panel is not the whole court, and it makes for better decisions if non-panel judges spot a problem or an error in a panel opinion. They should be free to point that out, and then discussions would ensue and back and forth would ensue, and that's exactly that kind of communication between judges is what the deliberative process rule is supposed to protect. And it seems to me you don't want judges talking to each other. And in that case, we're not going to produce the same quality of opinion. And in the city of Virginia Beach, well, I guess it's U.S. Fish and Wildlife Service versus Sierra Club. It says the privilege shields from disclosure documents reflecting advisory opinions, recommendations, and deliberations comprising part of a process by which governmental decisions and policies are formulated. And then our own decision in City of Virginia Beach says these sorts of exchanges are deliberative because they reflect the give and take of the consultative process by revealing the manner in which the agency evaluates alternative policies or outcomes. And if all of this, if early opinion drafts and comments are going to be made public, judges just aren't going to call. They aren't going to offer anything. They're going to pull their punches, and we're going to lose much of the quality that deliberative process brings about.
So I would draw your honors to the discussion in the briefing with there's a whistleblower case, Fitzpatrick.
I'm talking, isn't the gravamen of your position that you do not want non-panel judges and panel judges even talking to one another, despite the fact that they are members of the same court, that they are responsible for following and producing the court's decisions, and you don't even want them talking to each other?
No, that's not our position, Your Honor. The whole point is...
Well, you're changing your position.
No, our position is that in the APA and in the regulations we cited, that it's not that those discussions are impermissible per se. That's never been our position. Our position is that...
That is your position. your position was that they couldn't even circulate opinions among their peer group of judges.
No, we were,
You actually called it misconduct.
well, the misconduct comes when it's secretive. So our position's
Well,
been.
it's got to be secretive to be deliberative. In other words, if you lay it all out and provide notice of it, then you have the public participating in the deliberation that judges engage in, and you're going to have a very, very different outcome.
Well,
If you can't,
yeah.
if you can't have,
Why is it misconduct for me or Judge Niemeyer or Judge King or any judge in this country to talk to another judge about how a particular opinion might be approved or shored up or whatever? You didn't raise the government misconduct point below, for one thing. For another thing, the government misconduct is something you want to add to the statute, which isn't there. And the third thing is, how in the world can it be government misconduct for any judge of our court to communicate with another judge about how how the opinion could be made better and improved? It goes to the heart of strangling the judicial process as it has operated in every court across this country.
So our position, and we cite a reg that was in existence at the time, and then the APA, and then just due process, was if there's going to be deliberations about fact issues in the case, and in particular in this situation, it was done by a panel that exerted influence over the decision. So it wasn't just judges consulting at the water tank. It was a situation where, and that's why I ask Your Honors to really look at the Fitzpatrick case, because it was a whistleblower case where the whistleblower won his case. And the reason why he won it was there were deliberations going on. There was three impaneled judges, but a chief judge, two judges and a deputy chief judge with authority said the decision, which had been written, it should come out this way instead. And the impaneled judges said, well, if you're going to tell us how to rule, then we should at least let the parties know that this is no longer a three-panel judge, it's a five-panel judge.
Particular procedures there is a matter for the Federal Circuit to straighten out. But your point was, you have said that the circulation, and that is your position, and it's as clear as it can be, that the circulation of opinions among non-panel judges, which every circuit in the country does, you say that's governmental misconduct, it's impermissible, it violates the due process clause, it violates the APA, violates the PTO regulations. I can't find that it violates any of those. And I just do not accept in any way, shape, or form that it is governmental misconduct to try to produce the best opinion possible.
So I would emphasize two things to that. One, our position is primarily that they're not deliberative if there is a violation of the governing law. And so...
Does that mean one judge can't consult with the other judge?
Well, meaning...
In your view, what about consulting with their law clerks?
No, here we're focusing specifically on the communications at issue are between the impaneled judges and other judges in the CJP.
You're not answering Judge King's question, because your position went so far as to say any consultation outside the panel process was impermissible. And that way, and in fact, you talk specifically about staff, like law clerks. You want to just take the deliberative process and strangle it in the crib.
Our position, if you look at the communications that were withheld that we're still seeking, those are communications very similar to what was at issue in the Fitzpatrick case, which are communications where impaneled judges are in communication with non-impaneled judges discussing about the facts of the case. And we're not saying that those are...
What's wrong with discussing the facts of the case? I mean, it seems to me we can't create hypotheticals here, but when you circulate opinions, just take the circuit courts across the country, they circulate opinions to the whole court, and the non-panel judges will make comments. Now, if they say raise a question about, was that fact really there, or that fact seems to be inconsistent with this fact, you may want to take a look at that. The question is, you want to eliminate all that, right?
No, we don't want to eliminate it. We want the
That's what
same
your
outcome
proposition
that happened in Fitzpatrick, which is simply,
Well, you say it violates the due process clause.
in the absence of disclosure, in the absence of at least informing the parties, as was in Fitzpatrick, that this wasn't a decision by 3 panel judges, this is now essentially a decision by 5 judges. And so our problem is not so much that the discussions occurred, it's that they occurred in secret.
How many judges' names were on the opinion?
On the Fitzpatrick one?
One judge is at the top of the opinion,
Right, the 3,
and 2 concurred,
correct.
and that's who made the decision. The one wrote it, and 2 concurred in it.
Yeah, usually for the IPR cases, it's just a first listed judge, and then 3 judges sign on.
Excuse me, but how is that a violation of due process if you have one judge writing the opinion and 2 concurring in the opinion, and the 3 judges may have received the benefit of comments, as they do all across the country, from non-panel members? You've had 3 judges that, with the best of advice available to them, have come up with the best opinion they could have, and that would satisfy the way the judicial process is supposed to function. And you're saying that deliberation is a violation of due process? It seems to me that you got extra process in a constructive way. It's not a violation of due process. It was properly functioning process that took advantage of the information and comments and experience of other judges to make the final product a good one. That's all that happens.
I'm out of time, but may I address the question?
Yes?
Okay, so again, I would point to the rule in Butts, and we've highlighted it multiple times by the Supreme Court addressing the reg in question, the statute in question, when the government said any person or party, including other agency officials. And an important point on that is, in the agency's briefing, they said, well, Butts predates the definition for person, and so they at least suggest the Butts opinion saying including other agency officials shouldn't apply here.
What are you talking about here? Are you talking about the PTO regulations?
No, I'm talking about the APA that we cite to for a violation of due process.
Well, we're not talking about that. We're talking about whether judges can have other judges consult on an opinion so as to make them pre-decisional and deliberative. And if they're pre-decisional and they're deliberative, FOIA does not require their production.
I guess our point then is we interpret the governing statute, the APA, and the regs to require, to not prohibit that, but say there must be notice given to the parties, and here there was no notice given. And so,
But the APA definitions, they define, preclude certain things. But it's interesting that the APA definition defined person, which is at the heart of the prohibition, to exclude an agency. So the APA itself would seem to not to prohibit intra-agency discussions because the term an agency is excluded from the prohibition.
and thank you, Judge Wilson, that was the point I was trying to get to. That definition that you just are reading from was operative when Butts was decided in 1978. There wasn't a different definition before the Supreme Court, and under vertical stare decisis, we are required to accept the Supreme Court's decision and its interpretation of Section 554, in which the Supreme Court said any person or party, including other agency officials. And so our position is simply,
Thank you.
okay, thank you.
Counsel, I'm going to ask my co-panelists if they have further
Sure.
questions.
No, I'm fine.
Paul, you-
I'm fine.
Thank you.
Thank you.
Mr. Metzger.
Good morning, Your Honors, and may it please the Court. Matthew Metzger for the United States Patent and Trademark Office, or PTO for short. The issue in this case is whether the district court properly upheld the PTO's withholding of records pursuant to FOIA Exemption 5. It's not an APA case. It's not a due process case. This is a FOIA case. And as such, we're looking to whether draft opinions and discussions of those draft opinions are the quintessential examples of pre-decisional and deliberative records. Because they are, they're therefore protected by the deliberative process privilege, they are therefore exemptable under FOIA Exemption 5, and this court respectfully should affirm.
There's no clearer or more classic example of the deliberative process's work.
I entirely agree with Your Honor. I agree with Your Honor's opening remarks that this case is quickly resolved by City of Virginia Beach and Sierra Club, that there are only two elements, and just two elements to the deliberative process privilege. Is the record deliberative?
This is Exhibit A and the prototypical example of how the deliberative process, of why there's a deliberative process exclusion, and of how the deliberative process is supposed to function. This is Exhibit A.
I entirely agree with the court. I think the privilege was designed to avoid the chilling of agency discussions. The record supports that, opening up the discussions between the authoring PTAB judge and her or his staff, the PTAB judge and her or his colleagues, and then to the larger pool would effectively chill and undermine the work of the agency, which, as this court has already noted, is designed to provide a measure of quality control to ensure consistency with not just the agency, but also react to decisions from the Federal Circuit to promote continuity.
One of the things we need to do is we need to produce circuit law that is free from intra-circuit conflicts. And in order to have some sort of uniform position or uniform rule of circuit law and not having intra-circuit conflicts, you need sometimes to have non-panel judges comment on something and say, hey, I think there's an inconsistency here. In other words, these consultations are important in avoiding intra-circuit conflicts, and the federal rules place a high premium on not having intra-circuit tension.
I agree, and I think the same could be said for agency rulemaking, where consistency and non-arbitrariness are a hallmark of what we want from government agencies and their functionality. And so that's why this circulation function, or even the ability to communicate with staff to just catch basic Scrivener's errors, is just so key, and ultimately why there's a significant chilling effect. And so what has always been understood in the FOIA context, taking a step back and thinking less about the doctrines of deliberative process, is whether the governing test is set forth by the Supreme Court's decision in Grolier, is whether or not the underlying record is routinely disclosed in civil litigation. And draft opinions are not routinely disclosed in civil litigation. And my friend has yet to identify a clear, binding, articulating case suggesting that any type of draft decision or communications about said draft decisions are routinely, emphasis on routinely, disclosed in civil litigation. They are not.
I was under the view that his position, Judge King alluded to this, his position the logic of it was you couldn't even talk with your law clerks, or you couldn't even talk with staff, because the staff is not a panel judge and the law clerk is not a panel Article III judge. And that's the logical extension of it.
Oh, Your Honor, I agree with that, and I think it's most crisply advertised in reply at 11, where it was, quote, broadly prohibits ex parte communications, and that's the regulation. So under my friend's reading, the judge may only communicate with him or herself, not necessarily colleagues or staff, but then quickly he retreats to a new position, which is completely incongruous with his original statement, which is then that clerks are not bound by this prohibition. So I think this is a just make sure that only the communications between the PTAB and the PTAB authoring panel and the circulation judges are contemplated by this exception, and I'm fine with ignoring the rest. That's not a principled argument at all, and why, ultimately we've gone so far afield from the parameters of the deliberative process privilege.
You need to hear anything more. We need to hear nothing more on this.
Well, I thank the court for its time, and we'd ask that the court affirm. Thank you.
Your Honor, I just want to point out something from the briefing. When you look at, one thing my friend just stated for the agency is that it would have a chilling effect. Well, it's interesting. After this FOIA was filed, a number of regulations were promulgated by the USPTO addressing some of this undue influence that was happening by the circulation judge pool, the very issues that were raised successfully by a whistleblower, which is where the problem here was the communications involving unimpaneled judges were influencing the outcome of the decision, and they were in positions of power to do so. And so after Fitzpatrick, in fact, it was before Fitzpatrick, the MSPB recognized that there were new safeguards that came into place to address and limit what in-panel judges could do and who they could talk to. So everything in the briefing that talks about 37 CFR Section 43, all those regulatory provisions, those came in after the communications in question. These are all new regulations. So the suggestion that putting some type of safeguard in place or allowing a notice type of requirement would prohibit discussions or would prohibit talking to staff is just wrong. And let me give you some examples of what these new regulations did. Section 43.4A, again, after these were promulgated or entered months after the time period in question, about 6 months, I think. 43.4A now prohibits a management judge or an officer or employee of the office external to the board from initiating communication directly or through intermediaries with any member of a panel regarding a decision. So the USPTO itself is limiting certain types of discussions. Section 43.4 now makes it optional what was required in most cases. In other words, optional and solely within the discretion of an individual panel member can they consult with the circulation judge pool. The problem was before that it wasn't optional. In most cases it was required, and the people that they were consulting with had influence on...
What's the difference of that? What we're talking about here is a FOIA request.
Sure.
We don't have a separate lawsuit. We have a FOIA request, and the FOIA request excludes pre-decisional deliberative material. Pre-decisional or deliberative material, and that's what this falls into. You don't deny that, do you?
No, I actually do deny it. I want to be very clear on this. When you look at the category...
The categories I thought were pre-decisional.
Let me read through them.
Drafts of the order?
There were essentially 4 categories. One of them was draft orders. One of
That's pre-decisional.
Right. Sorry, maybe I misunderstood your question. So, yes.
I'm saying that the FOIA delineation of what has to be produced and what has to be withheld, that excludes pre-decisional deliberative matter, right?
Yes.
Okay, and you're asking for that matter.
We're saying that our primary argument is not that the government misconduct exception should apply.
Draft opinions be made available to you.
Right, because there were...
A draft opinion that some law clerk prepares for me, or a memo a law clerk prepares for me.
No, that's not...
Well, that's what the...
No, they are APJ opinions. They're red line documents from another judge, a non-impaneled judge.
All right, I'll write the opinion and give it to my law clerk, and he makes it a red line.
No, but that's not
Takes the
what...
cites and rewrites it.
Those aren't the categories of documents that were withheld.
That'd be pre-decisional deliberative material.
Right, but the documents that were
That's
withheld...
what they give it back to me, I study it. They give it back again, and it goes back and forth.
The documents that were withheld were emails or communications between other judges, not law clerks, working for the impaneled judges, but...
Other judges too, it'd be the
Right.
same thing.
Right, so they...
Well, that's deliberative, isn't it, among the judges?
It's deliberative in the sense, and we're not saying you can't deliberate. Our point is, in the event you're going to discuss
I'm
facts.
just asking categorically, I mean, you want to go outside the FOIA statute to get these documents. You're basically saying it's misconduct or due process violation or something. But the statute says, defines the limitation in terms of pre-decisional or deliberative matter. And that's what you are asking for. So it seems to me categorically, you start with the proposition that the FOIA denial was appropriate under the statute. And your only claim is that, well, it's not appropriate because it's misconduct of some kind.
No, our position is that there are specific regulatory and new regulatory positions. Under the new rubric of Section 43, there could be some violations. Our position is that they're not deliberative.
No, but you have said that even the discussions of an exchange of draft opinions among judges or whatever is an example of governmental misconduct, and that there is a governmental, without any citation to any opinion, you have said that this kind of circulation is an example of governmental misconduct. And you didn't raise that as I see it beforehand. It's not in the statute. And I just do not understand. I'm not a believer in, the government is pure, but I do not understand how it can possibly be misconduct for judges to try to talk among themselves to produce the best final product possible. How can that be misconduct when we're doing exactly the thing that we were put on the bench to do?
Well, I guess I would point again to Fitzpatrick, where there was a finding that there was a whistleblower finding that the circulation judge pool was exerting undue influence over judges and influencing the final product. And our position is that if you're going to have.
The final judge, the judge's name on it, you're saying is not trustworthy.
No.
And all these, what happens leading up to that final product can't be confidential.
Well, there are a number of concerns about who's writing the opinion. And if the opinion's being written or significantly influenced by two non-impaneled judges, the parties have a right to know that. They have a right to know who wrote the opinion. There's due process.
Who wrote the opinion, his name's on it. The one that wrote the opinion, his name on it. And that judge is responsible for the whole thing. And we trust them to get there in the proper way, to get it right.
So my time's out. I don't know if there's another question or.
Answer very quickly.
So repeat the question. The question is the judge who wrote it the judges whose name's on it? Is that the question?
It's his job to ask you the questions. It's not your job to ask Judge King the question.
I just want to make sure I'm restating it correctly. Yeah, so our position is that the parties have a due process right to know who is influencing, if another judge is influencing or partially writing an opinion, the parties should be on notice for that.
What about a law clerk?
No, that's not what we're talking about here. We're talking about other AP.
Judges can't influence it, but law clerks can.
Correct. None of the withheld communications are with law clerks. They're all dealing with other non-impaneled judges.
We're talking about categories.
Correct.
And your categories include law clerks.
No, if you look at the categories of withheld documents, they're all about other non-impaneled judges with the impaneled judges. That's the one point of commonality for the withheld documents.
Thank you, sir.
Thank you.
We'll come down and greet counsel and take a brief recess.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. Ms. Hernandez?
Yes, good morning. May it please the court. My name is Jill Hernandez, and I represent the appellant, Mumina Tauba. I will reserve 7 minutes for rebuttal. Respectfully, Ba's Title VII and Rita claims should have survived summary judgment based on this court's holding in Wanamaker and Driscoll. As in Wanamaker, Ba provided ample record evidence to support that SBOC's proffered neutral reasons for termination were probative of pretext. First, Ba offered circumstantial evidence of racial animus based on racist comments made by a person influential to the decision-maker, Frank Taylor, whose relationship to SBOC's ownership dates back 50 years. In fact, SBOC's goal for Store 98 from the date it opened were to be in the hands of white management, as evidenced by Taylor's warnings.
I thought the centerpiece of the reason for termination were the conditions, the candidly horrendous conditions at Store 80. That place was used for in connection with drug distribution, gun distribution, and mis-selling of cigarettes and illegal cigarettes. And all of it was totally out of control, and how that could have gotten to, that's why they terminated her, right? So the question is, you can take issue with that too, but I assume that was the reason it was terminated. It was a pretty quick decision in response to that. There had been some prior warnings, but the question then is whether that was a pretext, and the district court, I thought, went through that and discussed why it wasn't. You can address that, but it seems to me it's, sure, you have activities with respect to Store 98, but she got that back. There was a debate as to who, she improved that store, she kept that store. But her downfall was really letting Store 90, and I must say, what they described is pretty serious.
Yes, thank you, Judge Niemeyer. The reality is that this case is exactly like Wanamaker. This woman, Ba, had been there for 11 years. She had not had any performance issues. She had had stellar evaluations every single year for performance evaluations from 2019 to 2021.
I thought she got a whole new set of stores because of complaints about her.
No, in fact, that particular evidence about being swapped for a new district, those details specifically indicate that she was doing a great job by holding individual store managers accountable for policy violations because they were stealing.
I want to follow up on Judge Niemeyer's point here about the conditions in Store 80 were really horrendous. And you have, and that would seem to me, given the magnitude of the problems there, would seem to me to be a perfectly justifiable reason to let someone go. You said, well, but you can't do that because we were somehow relying on solely on the discriminator's testimony or what have you, to resolve the case. But I don't think that that's really fair, because the documentary evidence is quite extensive here. And in addition to the testimony, you have really voluminous documentary evidence, including investigation notes and written statements of witnesses and emails and text messages. And so the the record here is much fuller and more complete, and drawing on more different threads and strands of testimony than was the case in the Wanamaker on decision. They weren't just relying, in Wanamaker, they relied solely on the testimony of the very person accused of discrimination. But that's not here. That's not this case. The documentary testimony ranges far afield, or is much different from simply the sole testimony of the discriminator. And those conditions that existed in this store, really, that's not related to the testimony of the discriminator. Those conditions were there, and they were horrendous. And any company would want to say, you're the supervisor, you're responsible for what happened there. It hasn't been cleared up. And in addition, there are, the record is replete with a consistent explanation on the part of the company about communications problems. They're not hopping from one reason to another. They're talking about communications problems with the people that she's supposed to be supervising. And so to say that this is a Wanamaker case, just, I don't see how they're similar at all.
Your Honor, if I may just explain, it will certainly come clear as I can provide a little bit of the timeline. First, all of these details go to shifting and conflicting motives, which we know from Wanamaker is probative of pretext. Unlike in Wanamaker, where Wanamaker was given one reason for her termination, here, SBOC articulated no reason for Ba's termination. Shifting 2 weeks after her termination.
You just said the defendant didn't give any reason?
That is correct. That is correct. In fact, on July 7th, 2022, when she was terminated, she was given a singular page report that had policy violation 11 and policy violation 29. All that said, all that meant, and she specifically, Your Honors, she specifically asked for an explanation on why she was being terminated, and they wouldn't give her one. In fact, Manley Clark, the decision maker, specifically advised her to go ahead and call HR the very next day. She calls HR, and that HR lady, who was directed just the night before termination, was directed to go ahead and find any information to corroborate or justify Manley Clark's decision
Manley spent
to turn
a whole page testifying as to why he fired her. And
You
he
want-
said, and he concluded that he's never seen, he said there was such a complete lack of control there, I'd never seen anything like it in my life. And Shannon and I decided that that was the reason for termination at that point.
Your Honor, but that is exactly like Wanamaker, where in Wanamaker, this court held that where the decision maker is directly criticizing the employee's performance, and that employee is directly disputing that evidence and also accusing that person.
I mean,
Absolutely.
We're talking about hiring somebody that murdered his wife. We're talking about shortages in the cash register. We're talking about selling cigarettes illegally. We're talking about selling drugs for, I mean, he lists it right here on page 2058, the whole schmear.
Your Honor, let me just say.
Nobody has disputed any of that.
What we can say is this, as it relates to, I said, the very first day she was terminated, there was none of this information that was given to her.
Well, that's a different issue.
So
The question is why they fired her.
So then 2 months later, after her termination and during her unemployment hearing, that information relating to Store 80 came up for the very first time. And then 2 years later, during her deposition, there was now a new reason that was serious misconduct. This was the shifting and conflicting motives probative of pretext. In fact, as it relates to Store 80, she, during her deposition, responded to every single issue and how she addressed it. Why? Because she had 8 to 9 stores under her supervision, and whenever HR would get a hold of something or would hear something, they would direct her to investigate, and she did. She would address every single issue. As it goes to your point about the murder, there is no evidence in the record that she was responsible for hiring this
She's not
person.
responsible. He said she was totally out of control, that this store, I mean, it's quite a problem. There was a cigarette investigation in which she had complete lack of control or oversight of her stores. There were the vacancies in her management spots they were having issues filling. Their things ultimately got out so out of control that in Store 80, where there was a complete lack of oversight or patrol whatever, there was cash shortage, there were employees trying to buy and sell guns, drug issues in there, a drunk employee urinating on the floor. There was an employee that was previously terminated and rejected from being hired, that somehow got hired into that store, just to show the character of what, and he just goes on, and then that person happened to have murdered his wife, of course, her boyfriend.
With all due respect, Your Honor, she was never given, there was no contemporaneous documentation.
What's that?
There was
That's not a
never.
requirement. It's a question of why they fired her.
Consistent with Wanamaker, there has to be contemporaneous documentation. We know from Wanamaker that the decision maker that is attempting to build a file of issues that have never been discussed with a plaintiff is probative of pretext. When there is documentation that is created at the time of termination, where they're relying on past events, and there's no contemporaneous documentation, that is probative of pretext, and that was present in this matter. Your Honor, may I? I'm sorry.
I was going to say, it was true that a white individual ended up replacing Bob, but the company says it's undisputed that this occurred only after 2 individuals within Bob's protected class had declined the job. And that was just another fact, I think, that supports what the trial judge, the very able trial judge, had done here. I'm just wondering, that seems to sort of defang the whole idea that this was racially motivated, because 2 black women were asked to take the job, and the white individual only replaced Bob after the 2 women within Bob's protected class had declined it. So, you know, the various performance reports seem to me to be consistent in identifying a problem. In addition to Store 80, the one persistent criticism that arises is the problems that she had with communication issues. Were the communication issues, did they involve subordinates, or did they involve, were they upstream communications issues? I'll ask the other side of this, but this one problem continues to surface.
Your Honor, if I may, I realize that my time has expired, and if I may address your question.
Would you prefer to address it on rebuttal, or do you want to address it now?
I would prefer to address it now.
Okay, that's fine.
So.
Then that'll take your time off your rebuttal.
Thank you, Your Honor. The first point is that in terms of any the communication issues, this woman for over a decade working there, and she had never had any formal write-ups. She had never had any sort of PIPs. She had nothing but positive feedback, including from Frank Taylor, 30 days before her termination, where he investigated all of her stores.
The performance reviews declined toward the end of her tenure.
And yet she still received a salary increase, which was reserved only for individuals that were performing at above average skill, and that was her. The comments were always stellar. She was doing a fantastic job. She had maintained a wonderful team, that she was amazing at finding shortages and inventory audits. All of this information about Store 80 came to light 2 months after her termination. She had never heard any sort of write-up, anything. In fact, as I stated, at the time of her termination, they didn't even give her reason, and she asked for it repeatedly. And then 2 years into the litigation and during her deposition, she is seeing for the very first time a draft termination report that says serious misconduct. She had never seen that. How is that any different from what happened in Wanamaker, where the shifting and conflicting reasons by the company are demonstrative of pretext? That's exactly what we have here. And so summary judgment should have been denied because a rational jury could find in favor of the plaintiff, and that's what's really at issue. This is not about weighing the facts when they are conflicting.
Thank you, Counsel.
Thank you very much, Your Honor.
Mr. Penfield?
Good morning, Your Honors, and may it please the Court. Nate Pencook on behalf of the appellee, Sampson Blade and Oil Company. Your Honors, this is a straightforward pretext appeal in which the district court faithfully applied well-settled Title VII jurisprudence and correctly found that the plaintiff had not established a genuine issue of material fact that the reasons for her termination provided by the company were pretext for race discrimination or for any qualifying complaints she may have made. The plaintiff asked this court to reverse the well-reasoned decision below for 2 reasons. One, based on a flatly incorrect representation of the facts, and also by an unreasonable extension of the Wanamaker case, as we just heard. Plaintiff's interpretation of Wanamaker would effectively eliminate summary judgment for employers if that were the case. This court should reject that argument. Now, the first argument I'd like to address from the briefing is that Ms. Baugh argues that because the district court found a prima facie case was made by Ms. Baugh, that its findings on pretext conflict. And they don't, Your Honor. That argument is based on a misapprehension of the McDonnell-Douglas test and the relative burdens at each stage. There's nothing that's inherently contradictory about a court finding, on the one hand, that the minimal prima facie burden has been met, and on the other hand, that the pretext burden was not met because the inquiry is different. At the pretext stage, what ultimately matters is the employer's honest belief. As this court noted in Semplewich, the court's focus at the pretext stage is on the employer's perception rather than the employee's self-assessment. And so, as an example, this court in Holland versus Washington Homes found that a plaintiff had made a prima facie case based on positive performance reviews, but ultimately that the plaintiff failed to prove that the reasons provided by
I think we understand the legal framework.
Yes, Your
So
Honor.
just, why don't you get to the facts of the case?
Sure, Your Honor. And perhaps the best way to address that is in the context of Wanamaker, because this case has been analogized pretty heavily to that case. Wanamaker found pretext based on several reasons. First, there was discriminatory animus by the alleged decision maker. We don't have that here, Your Honor. The decision maker here, Manley Clark, is not somebody who the plaintiff alleged had it out for her. There's no evidence that this man made any sort of racist statements. And so it's very different from the employer decision maker in Wanamaker for that reason. There's been a lot of discussion about the shifting and conflicting reasons provided. There was no shifting or conflicting reason provided here. The discussion of this draft report and the final report that she was given, which are 2 days apart, there's nothing inconsistent about those two.
What were the communications issues that were referenced here? Were they poor communications downstream with subordinates or upstream with supervisors? Or
It was upstream with supervisors, Your Honor.
did they just not, were the communications issues that were referenced, that she failed to let them know what was going on within the different stores under her supervision?
That's right, Your Honor. And this was an issue that was consistently noted in her performance reviews over the preceding years.
Yeah, this wasn't something that just blossomed at the very last minute. It's a persistent comment
That's right, Your Honor.
throughout a good number of years.
That's right, and, another instance of poor communication actually occurred in June, which is the same month that all the issues at Store 80 became apparent, where Ms. Baugh was supposed to be out for the week, apparently worked that entire week after the company had already gotten coverage for her for that whole week, and at the end of the week, after it was all said and done, she said, "Oh, I worked the whole week." Ms. Shannon Herring, who was her direct supervisor, and Mr. Manley Clark, who was the decision maker, both told her that is a communication issue, that is a
All
problem.
right, now what about the conditions? And you've addressed the communications issue. What about the conditions in Store 80?
Yes, Your Honor, the conditions at Store 80 were the worst that Mr. Clark had seen in his time with the company. The issues essentially demonstrated a lack of control over that store, but they were also exemplary of just the issues that she had with control over her district. And so the issues that were there were a store manager who was largely absent, was soliciting his employees to buy guns for him that he claimed he wasn't able to purchase based on his citizenship status, and drugs for him, and in exchange he would mess with their timesheets to get them more money from the company.
So he was altering timesheets in return for drugs?
Correct, Your Honor.
You're saying mess with timesheets, you mean falsify timesheets
Correct, Your Honor.
consistently?
Yes, Your Honor.
How did this come to light?
So it came to light when both that store manager and the employee who was involved made dueling complaints to the company's HR staff. Once those complaints became known, Ms. Herring and Ms. Thornton, who was the HR specialist, conducted an investigation. They interviewed those employees, and what came out in that investigation was that Ms. Baugh was aware of very many of the issues, and said that she would tell her supervisor about it, talk to them about it, and nothing ever happened. That's why the employee, not the store manager, but the cashier, went directly to
But
corporate.
the conditions in Store 80, they involved unlawful acts.
Correct, Your Honor.
We're not just talking about poor performance here, we're talking about illegality.
Absolutely, Your Honor. And
Whether the company could simply avert its eyes and sweep under the rug activity that was in violation of very basic laws.
exactly correct, Your Honor.
Were they ever reported to the authorities?
That's not in the record, Your Honor, but the employees were no
On
longer
this
with the
record, they
company.
weren't reported to the authorities.
I'm sorry?
On this record, then, they were not reported to any authorities.
Well, there's no evidence in the record one way or
Any
another.
unlawful activities, or 80, for example.
There's no evidence in the record one way or another.
You didn't turn anybody in.
That's correct, Your Honor. At least there's no evidence of that in the record. But regardless, that is a key distinction between this case and the Wanamaker case, because in the Wanamaker case, the plaintiff there failed to respond to an email in a single day. That is, a far cry from issues at a store that are described as the worst that the company had ever seen. I'd like to address briefly, because it may appear from the briefing that the record is not clear on this draft report and the reasons being shifting and conflicting. The reasons provided in the draft report were more specific to Store 80, and they had all these investigation notes attached to them. But the final report was these two issues: the failure to communicate, the failure to ensure that the employees at the company were following policies, are part and parcel. And
What was she told when she was fired?
when she was in the termination meeting, she was read that report that just said the two issues of failure to meet job responsibilities. But it's important to note that in Wanamaker.
And Manley fired her?
Yes, it was Manley Clark and John Clark who made the decision.
Who was the other one?
John Clark, the vice president of the company. So Manley, and what's in the record is Manley determined she needed to be terminated.
What about Shannon?
She was also part of it, and she was part of the Store 80 investigation as well.
Was Taylor part of it?
Mr. Taylor was not part of the decision to terminate. Mr. Taylor was consulted after the decision had been made as to what should be put in the report, like essentially how it should read, and what should happen in the termination meeting.
Am I correct that two black employees were offered this position to replace the plaintiff here, and they declined it? And then a white eventually accepted it, but there were two employees within the same protected class that were offered the position initially. Is that correct?
That is correct, Your Honor, and we argued before the district court that should mitigate the prima facie case, because that fourth step of circumstances that give rise to an inference of discrimination essentially looks to, okay, if the company had an issue with having a black employee, they replaced her with a white employee, and that's sort of prima facie evidence. But if the company made honest attempts to hire somebody in the same protected class, not because they were in the same protected class, but because they were the ones who had the most merit for the position, and those individuals declined, the company shouldn't be held liable for race discrimination based on that alone. Ultimately, the district court found that was more appropriately considered at the pretext stage, and certainly we do not quibble with the decision that the district court made. Your Honors, I'd like to make it clear that there is no genuine dispute by Ms. Baugh that the issues at Store 80 actually occurred, or that they were actually the basis of her termination. Going back to the case law that says it's the employer's honest belief that matters, there is no evidence that this reason was false. All she offers to rebut that is claiming that Wanamaker says you don't consider the employer's testimony whatsoever on summary judgment, which is flatly incorrect. And then also that she claims that she wasn't aware of these issues. That's exactly the problem that led to her termination. The company expected her to be aware of these issues, to be in the stores, to be talking to the employees, and to address things that are brought to her attention, and to find things that had not been brought to her attention.
Was it that she did not visit the store, or that she visited the store and didn't pick up on the problems?
Well, ultimately, what the record reflects is there were several store managers who said, and this was following the store rides that Mr. Taylor did prior to this termination, there were complaints that they just never see Ms. Baugh, or they don't really hear from her, except for on very limited occasions.
She didn't go to Store 80?
Well, she was aware of issues at Store 80, and she was at Store 80, I believe, addressing issues related to a cash audit. But there were all these other issues which, if she was there, I mean, she would have knowledge of the store manager being in the office, 2 to 4 hours every day, as opposed to working full shifts and that sort of thing.
Where was the Store 80?
Store 80, it was in East Raleigh.
East Raleigh.
Yes, sir. To briefly address the Rita claim, Your Honor, ultimately, the issues that led to her termination undercut her Rita claim, but what the district court found is that Ms. Baugh had not made a qualifying complaint, and that was correct. What Ms. Baugh argues now on appeal is that the Driscoll case essentially means that if she makes a complaint to anybody other than her supervisor, that means that she's made a qualifying complaint. But there's no evidence in the record here that she did make a complaint to anybody other than her supervisor during a relevant time frame. Now, she raised the concern about, store managers being paid more in the context of employee retention and competitiveness, but it was never made in the context of.
There was an increase, wasn't there, after that?
And there was an increase, Your Honor, yes, sir. However, there's no evidence that it led to any sort of investigation as to whether wage and hour laws were being complied with. It's essentially saying, we're having a hard time recruiting store managers, I think we need to give them a little bit of a pay bump. Or we're having a hard time retaining store managers, I think we need to give them a little bit of a pay bump. That sort of a suggestion doesn't rise to the level of a qualifying complaint in the same way that, for example, the complaint in Driscoll did, where the individual was complaining about a drunk employee on a construction site to the president of the company, and it was a persistent complaint that was made numerous times. We don't have that same issue here. Ultimately, Your Honors, this case ends where Store 80 begins. There is no evidence that the company didn't honestly believe these issues merited her termination, and there's no evidence that these issues did not occur. And as such, the district court correctly found that Ms. Baugh had no competent evidence to counter that, and under McDonnell Douglas, under any reasonable reading of Wanamaker, and based on the undisputed record, the district court properly entered summary judgment, and that judgment should be affirmed. I'm happy to answer any questions you have.
Thank you. Ms. Hernandez?
Thank you very much, Your Honors. To first address the Rita issue, the district court incorrectly held that Baugh should have inquired into SBOC's legal obligations under the North Carolina Wage and Hour Act. Consistent with Driscoll, that is not the appropriate standard, that somehow that would have been Baugh's requirement to investigate what SBOC's obligations were. Additionally, as it relates to her complaints to Frank Taylor and Manley Clark, that they do not count, they were within the leadership, she was within that leadership command. She obviously had communications with her store managers. The store managers repeatedly complained about working long hours, 50, 60, 70 hours a week, and wanting to be paid overtime. And she was complying with the company's policy by communicating those concerns to upper management. She, at a leadership meeting, complained about the overtime pay that they wanted and it was with the president and the vice president, which then subsequently, from 2021, early 2022, the company made a change in policy precluding store managers from recording their overtime hours so that it wasn't going to be documented. They probably wouldn't see it, and they wouldn't. Precluding store managers.
They couldn't document their overtime.
That is correct. And it was because they were complaining constantly, seeing how many hours they were working and not getting paid the overtime. So what did the company do after Baugh was complaining on their behalf? From now on, nobody's going to be writing down their overtime hours. That way it's not documented. They can't see it in any sort of investigation or further litigation. There is no evidence of what hours they are working. So it is absolutely not true that they didn't engage in further investigation and change the policy. Additionally, the district court respectfully incorrectly held that Ba's complaints were not part of that investigation. That's just not true. She did comply with these communications, and then going back to whether or not these two blacks were offered a position after they terminated her, there's no evidence that they offered two blacks the position and then that they rejected it. There's no evidence of that. The other thing is that
Where does it first appear?
where does it first appear? It appears in briefing, actually, because there's no evidence of that, and there should be
So you're
contemporaneous.
saying that's not in the record?
It's not in the record or contemporaneous documentation, I
So
should
you're saying
say.
somebody made it up?
I'm saying.
If it's not in the record,
It's probative of pretext. A rational jury should be able to decide whether or not that actually happened. And we don't have that in the record. The other thing to keep in mind is that Frank Taylor was influential to the decision maker up until the date of termination. And he was the one who made decisions about Store 98, and that because of its location, very affluent area, predominantly white, that they could not hire blacks or Africans because they were dirty, smelly, and lazy. They had an image to uphold, and they did not want it to be referred to as a hood store. So following those very, very racist and offensive comments, it's what happened all thereafter. She was deprived of her ability to do what she was supposed to do, to be able to hire the most qualified individual, even if that meant that individual was black. They deprived her of that. They always push back. Then they try to reassign her store to a white person. There were two black DM'd. They could have immediately given that store of hers to another black DM. They never did that. There's no evidence in the record that they ever tried to reassign that Store 98 to another black person. And why? Because they didn't want it in the hands of a white manager. And then when she was terminated, the very next day, they offer it to a white person and that person accepts it. Then, not a week later, they remove the black store manager from Store 98 and they give it to a white manager. All of this is probative of racial animus for unlawful discrimination, and with respect to Rita, she did absolutely what she had to do. She complained to upper echelon people, the president, the vice president, the director of operations regarding the overtime issues. And to the extent that your honors have any further questions for me, I'm happy to answer them.
All good, Bob.
Good.
All right, we thank you. We will come down and we'll adjourn court and come down and greet counsel. I'd like to thank also our able courtroom deputy for helping things move so smoothly.
Thank you, your honors. Thank you very much.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.